Counsel on each side will now present their closing arguments or summations of the evidence. Counsel for the state will have the opening summation. Counsel for the defendant will then have an opportunity for reply, and because he will only address you once, he will also present his summation. Counsel for the state will then have an opportunity to rebut the argument of the defendant. The counsel for each party will be summarizing the testimony that you have heard and the evidence which has been presented during the trial. They will merely be recalling the evidence as you will later. They will not intentionally try to mislead you, and if their recollection of the testimony is not the same as yours, you must follow and rely on your own recollection. The summations of counsel are merely that, summations. They are not evidence, nor should they be construed by you as evidence or instructions on the law. The summations are intended to help you understand the contentions of each side. You should give them your close attention. Ms. Linus, are you ready to proceed?
Yes, Your Honor.
You may proceed.
Okay, please support counsel.
And ladies and gentlemen of the jury, what is this case about? It's about last June 12th, 2015. Andrea Kozak arose that day as she usually did, started getting ready for work, had cereal, put on her clothes, did her makeup. She put on her Children's Museum t-shirt that said Playologist in the back. She didn't know she wasn't going to live to see her 21st birthday. She didn't know what was going to happen that day. But what happened is why we are here. Andrea Farrington got up that day and she made a fatal mistake. What she did was she bruised a man's pride, caused jealousy, and because of that, the defendant walked into a crowded mall, took out the gun from his right pocket, his Glock that he had brought from home after he left the mall, came in, went within feet of her, held it level, and shot her 3 times, twice in the lungs, once in her heart, and hit her spinal cord. Because of his bruised pride and his jealousy, he shot and killed Andrea Farrington. What he did was he committed the crime of first-degree murder. You may be wondering, after you heard the opening statement from the defense counsel, why did we put on all of the evidence in this case? Well, now you have heard the instruction, and the judge explained to you that a confession alone or a statement alone about what he did is not sufficient, but the state has to prove each and every element of the charge of first-degree murder. So for that reason, we had to bring on the different witnesses, and I want to talk about what you heard. I am not going to go over in detail the 2 weeks of evidence you've heard. I am not going to show you every exhibit. I'm going to show you very few because I trust you saw them at the time, and I also know you will have the exhibits with you when you go in to deliberate. So if you want to review, whether it's pictures, text messages, or anything, the video, audio of the recordings with the defendant, you may do so in the jury room. But what I want to do is talk about the highlights in this case. The state charged the defendant with murder in the first degree, and that requires us to prove by proof beyond a reasonable doubt 4 different elements. The first one is that on or about June 12, 2015, the defendant shot Andrea Farrington. What was the evidence that you heard about this? You heard from Catherine Ogden, who is a U of I emergency room employee, and she talked about how she arrived at the Coral Ridge Mall just planning to run in and get food. But she saw the defendant drive rapidly by her, almost hit her, park in a handicapped spot, and she was concerned about his driving. She wanted to confront him, She went into the mall and waited for him. When he came in, his attire was interesting to her, the black fedora, the black clothing. And when he came up to her, her intent to scold him and get on him about him almost hitting her in his driving lessened because he had such a focused look. And what she said to him was, "You shouldn't be driving so fast," or words to that effect, and didn't continue with it. However, she did watch to see where he was going because she believed he was an employee possibly, and she wanted to talk to his boss about it. It made such an impression on her what he had done. Instead, what she saw is he walked over to the Iowa Children's Museum Welcome Center. She saw him pull out a gun from that bulge she saw in his pocket. She saw him hold the gun out and shoot 3 times. She described what happened then and how she ran into the Mellow Mushroom trying to get away, told the people in there they should lock the door, eventually ran outside with the crowds who were trying to flee the mall, went back to her car, saw the defendant's car was still there, and pointed it out so other people could get a picture and get a description saying that's the shooter's car. We were lucky to have somebody like Catherine Ogden who was willing to come forward and tell the police what she saw. Here she described, and you'll get to see those photos better, the outside of the Coral Ridge Mall, and she described where the defendant parked, where she had parked, where they entered. You also got to see State's Exhibits 3, and you can look at these more closely, that explain where in the mall, if you've never been there, where the carousel is, where the kiosk is, where Miss Ogden initially saw the defendant, where she saw him shoot Andrea Farrington. You also heard from Bryn Stanton Anderson, who's an employee of the Iowa Children's Museum, works there doing cleaning. She knew Andrea Farrington. She described her as smiling, happy, somebody she enjoyed interacting with. She knew she was working at the mall on June 12th because when Bryn was there with her children, she had stopped over to check on something at the Children's Museum and saw Andrea Farrington and Carly Frederick conversing. She told you when she was leaving with her children, she saw the defendant driving up, and his reckless driving, in her view, alarmed her, and she wanted to confront him as well. However, when she made eye contact with him, his focus again was something that concerned her, and instead she grabbed her children and went towards her car. However, she didn't make it to her car before masses of people were exiting, and you saw the surveillance video of what the chaos was at people climbing over railings to get out of the mall. Next, you heard from Madison Tinkham. She's the 15-year-old high school student who was at the mall with her 2-year-old sister, her 17-year-old aunt, her step-grandfather. They were going to go to the carousel so her little sister could play there. Instead, while they were waiting for her grandfather to get the change to be able to play on the carousel, she saw the defendant come in, wearing the black fedora, the black clothes, as was described by Catherine Ogden as well as Bryn Stanton Anderson. And it caught her attention so much that she was concerned about the defendant's focus on what he was doing that she actually picked up her 2-year-old sister and held her to her. She then watched as the defendant walked over to the Children's Museum kiosk, pulled out a gun, and shot a young woman 3 times in the back. She described how the woman fell to the ground, and when she was turned over, she saw her lifeless eyes. She described how they were emotionless, and something she told you really impacted her a lot. She took her little sister, hid behind a column, and eventually went and hid in the carousel until after the paramedics took Miss Farrington out of the mall. She described what the defendant was wearing to the police, what she had seen, what he had done, and what her reaction was. She identified the defendant in the courtroom as the man who shot Andrea Farrington, as you had heard Catherine Ogden describe as well. Next, you heard from Carly Friedrich. She works at the Iowa Children's Museum. She explained to you what a playologist is. You probably got a sense about the happiness and lightheartedness that people who work in that museum may have from Carly's demeanor when she was describing her work there. She described how she was learning how to work at the Iowa Children's Museum, and Andrea Farrington had been training her, and how Andrea and she had been friends for some time. And so even though she was off of work on June 12th, she went over to the kiosk to sit with Andrea, and they planned to go out, do something later that day. She told you how they were sitting there, they had been laughing and joking. Andrea had shown her a text message from the defendant and pointed out the defendant, and this concerned or worried them somewhat, but didn't think anything would happen. She described, though, at around 7:30, as she was sitting at the computer desk at the kiosk, she saw, or she didn't see initially, somebody came up, though, and she heard the shots. She then saw that it was the defendant, Alexander Kozak, who had shot the gun. Believing this was a mall shooting and that she was going to be next, she ran in terror out the south side of the mall. After she got out, met up with Taha, their friend who had been conversing with them somewhat earlier, she went back in and talked to the police about what she had seen. Next, Taha, who worked at the Verizon kiosk at the mall, told you how he had been working that night, seen Andrea, Carly there, had talked to them, and happened to be going over to get a refill in his pop at Chick-fil-A. When he was standing near the kiosk at the time, he heard the shots. He looked and he saw the person he knew as Alex, a security mall officer, saw him with the gun and realized what had happened. And he told you it was Alexander Kozak who had shot Andrea Farrington. You heard from Jeff Carew, who was there with his girlfriend, his daughter's friend. They had dinner. Plans were made with his daughter to go to a movie. He and his girlfriend were going to split up as he didn't really want to go shopping that night. He told you it's his habit to go get a gumball, and so he went to the gumball machine. And as you'll see in State's Exhibit number 3, and as you look at it, and I realize it's too small here, but you'll see where the gumball machines were in this area, where the putt-putt golf exhibit was that Madison Tinkham was by. And you'll get to see kind of the proximity of where people were in conjunction with the Iowa Children's Museum Welcome Center. Jeff told you he later measured it out and believed he was about 13 feet from where Andrea Farrington was. He heard the shots. He knew because he's a hunter. He knew that they were gunshots. He was close enough that he heard the casings from the bullets fall near him. And you'll see from the picture where the different exhibits that Victor Murillo talked to you about, where the casings were found, and you'll see they're very close to where Jeff Carew said he was standing. He looked around to figure out, and he saw the man wearing the black fedora, dressed in black. He was going to chase him, was wondering what he should do, wanted to make sure his girlfriend and daughter was safe. He was concerned his daughter was at the theater, and is that where this man with the gun was going to go? He shouted to his girlfriend to get out of the mall, and then he described how chaos started. He realized then that Andrea Farrington was lying alone. No one was helping her. He went over and he took her hand and asked her to squeeze if she could hear him, and he got no response. He stayed with her, and when the medic came over, he said, "I'm a landscaper, you're a medic," and let them take over the care for her. But he described what he saw and who he saw shoot Andrea Farrington. Next, you heard from Ryan Ross. And Ryan Ross is an employee of Hawkeye Vapor. He happened to be somebody who was friends with the defendant. They had talked before, talked regularly. He had actually seen him the night or two before when the defendant was at the mall, also wearing his black pants, his black vest, his black shirt, and his black fedora. He talked to the defendant about different things, including the defendant's interest in guns, different things going on at the mall, knew him fairly well. He was working on June 12th when the shots rang out. I told you he didn't know exactly what they were initially, but realized then when somebody at the next kiosk said it was gunshots and to hide, and how he went into the Great American Cookie Company area, and he was behind kind of a glass encasement of different cookies. While other people were trying to hide in the back, he's looking out to see if there's other people he should bring to safety when he saw the defendant. And he started to think about waving the defendant over to have him come and be safe behind the Great American Cookie counter. And then he realized the defendant was not wearing his security uniform. He was wearing the black fedora and the black clothes, not what he had seen him in before on that day. And he also saw that the defendant had a gun. He watched and ducked down and waited and hoped he wouldn't be shot. He then went to find out what had happened and saw Andrea Farrington lying in blood. Went to the police then and tried to call 911 to tell them who had done this and who he had seen. Next, you heard from Rudy Rodriguez. Rudy works at Trade Home Shoes. You heard his testimony and how difficult it was for him to tell you. He worked at the mall and he had met the defendant. He had done his pitch, as he said, trying to sell him shoes sometime before. Certainly knew the defendant had talked to him because he worked at the mall, and many people who worked at the mall conversed. He told you on that night when the shots rang out, the 3 shots, he knew immediately they were gunshots. And he started getting people into the back of the store for safety and wanted to close the gates so he could close the store and keep the people in there safe. He told you how he went out into the corridor and a woman who was changing, or a woman in a stroller, was trying to get them to safety too. He then saw what he described as the black fedora walking behind the other kiosks. And he told you at that time he's thinking again of bringing in the defendant to bring him in for safety to get away. And then he saw the gun in the defendant's hand. And what does he do? He tells you, he says, I won't repeat it exactly, like, "What are you doing, man?" And he told you how he stepped back because he believed he had made himself a target and believed that he would be shot if he turned his back. He backed up into the store and watched the defendant as the defendant went down the corridor next to Trade Home Shoes. Now this corridor, and you'll see it, and you saw it in Kevin Elliott's video. But it's basically a service corridor that goes from the main hallway or main corridor to the restrooms, and then eventually outside where dumpsters are located. And you heard from Detective Kevin Elliott, who was an off-duty sheriff's sergeant deputy. He was there with his family, his wife, his daughter, son-in-law, and his grandchild. They had had dinner at Panera's, and you saw kind of where that was in conjunction with the Children's Museum kiosk and Welcome Center. He went over to use the Eco ATM to turn in his cell phone, see if he could get some money from his old iPhone, when he heard the shots. He went towards them, and he saw the defendant in black walking and then running down the main corridor, and he saw the gun in his hand. Detective Elliott followed him, holding his off-duty service revolver, tried to think of a way to stop, or I think he said neutralize the defendant, but because of the number of people in the mall, there was no way he could do that, and he just tried to follow. Eventually he lost sight of the defendant as the defendant went down the exit corridor towards the restrooms, and when he got outside, he couldn't see him anymore, but did talk to witnesses. You heard from him also when you got to see the surveillance video of the defendant running in front of Annie's Pretzels as well as Shields Sporting Goods. And you could see the defendant going by in his black hat his black shirt, his black vest, his black pants, and his gun in his hand. You next heard from Victor Gingrich, who was there at the mall with his wife. They were about to split up in front of Shields when they heard the gunshots. They went into the corridor towards the restrooms for safety and were going towards the end, and there was some discussion about whether he should go back and check. But when he turned around, he saw the defendant coming at him, and because of his attire, and he noticed he had something in his hand, he went ahead and rushed his wife out the door and outside of the mall where they hid behind a truck. And you heard him say it came to his realization as that man came out of the door that that was the shooter, that was the gun in his hand. He described how he saw the defendant go kind of behind two large, what we might call dumpsters, turned out to be compactors, and heard a door slam when the defendant was either in between or on the far side of one of the compactors. He wanted to make sure that he could help the police, so he told them about this, but he also followed the defendant who ran north in the parking lot and then east. And he went out and he actually took a picture with his cell phone, which was admitted into this, where you can see the defendant in the black hat, black attire, running through the parking lot. Next, you heard from Deputy Jeff Gingrich, and he described where he was and how he got there a little bit later, but how when he heard that there was a gun, maybe in the area of the dumpsters or compactors, he worked with another officer who had a bomb-detecting dog, and eventually looked and got into the dumpster, or the compactor actually, and looked around and eventually found the gun. And the gun that he found is the one that was admitted in this trial, the Glock. And you saw the pictures of how that Glock was wedged in the cardboard in that compactor, and how he watched it until the crime scene was there and they were able to retrieve it. Next, you heard from Jessica Preisler. She was at the mall with her husband Chris. They were having dinner with friends who had 2 children as well. They were at Mellow Mushroom. She described it was crowded that night, as many of the other witnesses had. They had to wait to get a table, and about the time they got their salads is when they heard 3 large sounds. She didn't recognize them at the time, that they were gunshots, looked towards the pizza pans to see if somebody had dropped them, realized then as people started to run it really was gunshots. She described how her husband tried to grab the child. They all tried to flee as quickly as possible out of the Mellow Mushroom. And you heard how when she got out into the parking lot, she saw a woman who had been kind of standing on the outside of Mellow Mushroom in the main area of the mall near the carousel or in that area, and had caught her attention and watched her. She thought she had a cat or something on her shirt. And when she got outside, she saw this same woman pointing to a car, saying, "That's the shooter's car, that's the shooter's car, take a picture." And she took a picture of it. Oops. And I apologize, our audio visuals are not working here, but you got to see a picture of it. And the picture she took was of the Kia Optima with Texas plates. And she related that, and her husband related that to law enforcement, and eventually it was radioed to the Iowa State Patrol to be able to find the defendant later on. Oops. You heard from Mike Barney, and an interesting thing with technological advances is you actually got to see his body camera. These are fairly new for law enforcement. It gave you an idea of what the chaos was like, what it was like in that mall as they were trying to help Andrea while they were trying to piece together what had happened and who was involved. You heard the chaos and how they eventually came up with the name that the shooter was Alexander Kozak. You heard from Scott Penrod, who worked with the defendant. He was a supervisor in security at the time, and he told you how the defendant was working that night, but at about 6:30 or 6:40, when he was looking for the defendant to change a channel on the TV, the defendant didn't respond to his radio calls. This concerned Scott, and he kept on trying. Had another officer go to the office and discovered that the defendant had left his radio and keys in the office like he was resigning. And he didn't see him again that night. You heard from Cypressong Insisime and Wendy Robbins, who worked with the defendant. They told you about his involvement, what they knew of it, which was minimal, about Andrea Farrington. Mr. Insisime had not been even working that day. Wendy had been working but got off. Didn't know anything about the shooting but helped in the aftermath. Based on the information, though, that they were able to provide, that all of these witnesses who were willing to come forward and tell what they had seen, provided their evidence, there was information provided to the Iowa State Patrol as well as other law enforcement agents to be watching for this Texas blue Optima or blue Toyota, and you saw how those two cars are very similar in shape. They had a license plate number that they thought was accurate, and eventually Trooper Engsler stopped the defendant. Trooper Engsler stopped the defendant, and you saw that video of getting him in the car. You heard also from Sergeant Varela, who arrived there quickly after. And you heard then from Special Agent Rick Ron. What did the defendant tell the troopers when they stopped him and got him out of the car and into the back of the deputy's car? I shot someone at the mall. When asked if he knew what it was about. When asked who he shot, he said, I shot Andrea Jean Farrington. When asked kind of to clarify that, he said, Andrea Jean, like the pants, Farrington. When Special Agent Ron asked him, the defendant again admitted that he shot Andrea Farrington. You next heard from Vic Murillo, who's a DCI criminalist. And he described to you how the criminalists go to the crime scene as well as do follow-up evidence analysis and things like that. When he got to the crime scene, he described what he saw, and you can see the pictures that he took that day showing the entrance, the location of the Welcome Center, the video that was shown, showing the layout of the Welcome Center, where different things happened, where different pieces of evidence were found, including all of the bullets, the casings, the bloody clothing, the bloody plastic that was found, all of those things, and you can see those photographs if you choose to that are in the exhibits. He told you, though, he did special analysis, and his specialty is in firearms. And what he did is he took the casings that were found from the bullets at the scene and the bullets that were found at the scene, and he did an analysis. And he told you about the comparison. And he did some test shots with the gun that was also retrieved in the dumpster. And he told you that the gun that was found in the dumpster or compactor was the gun that fired the shots, the bullets that were at the scene, and those are the ones that killed Andrea Farrington. There's the blue car. Texas plates DNF 6582. Here's what he found in the back seat. When Vic Murillo searched it, he found the black fedora, State's Exhibit number 22, the defendant's work hat as a security officer, State's Exhibit 23, the defendant's work clothes, State's Exhibit 24. He found the ammunition box, and the ammunition box was full of ammunition. You saw the pictures of how full it was with ammunition. and that it was packed. There were 2 additional loaded magazines in the magazine box. And you heard also from the interview with the defendant how the defendant said he had another magazine that he had thrown out alongside of the road in Cedar County that was not recovered. All of this evidence, all of this testimony from the witnesses, the exhibits, all prove that the state has proven beyond a reasonable doubt the first element of murder in the first degree, that the defendant shot Andrea Farrington. The Glock, as I said, was found in the Coral Ridge Mall. It compared, it matched. Vic Murillo also, though, told you something important, which he did some gunshot residue testing and discovered that the gunshot residue on Andrea's shirt showed that the bullet had been fired from a very close distance. It was consistent with what the defendant had told Special Agent Ron about how far away he was. It was consistent with the testimony you heard from the other witnesses saying how close the defendant was to Andrea Farrington. The other evidence at the scene, as I said, there's the video, there's the crime scene photos. Feel free to look at them as much as you feel that you can and want to. They were all introduced into evidence, though, to prove that the defendant is the one who shot Andrea Farrington. The second element that the state must prove is that the defendant's shooting Andrea Farrington actually caused her to die, so that Andrea Farrington died as a result of being shot. And the evidence for that is you heard the emotional testimony of Army medic Dorian Potter. Mr. Potter worked in the food court at the pizza place there, and when he heard the shots, he first got his employees to the back to try to protect them and told them where to go for safety. He then jumped over the counter and ran towards Andrea Farrington, who was already lying in blood. He didn't think about his own safety as he immediately tried to stop helping her. He yelled for people to bring bags and tape. He asked somebody passing by for a shirt so he could use that to plug the bullets. He described his process in using his medic training to do everything he could to try to save Andrea Farrington. They tried to stop the bullet holes from bleeding. They turned her over and saw that there were not only 3 shots in her back, but 3 shots on her front, or 3 holes in her front too. And as they tried to bandage them and tried to tape these around her so that the bleeding could stop, she stopped breathing. He heard gurgling before that and how he had reached in her mouth and pulled out blood that was in her mouth, trying to help her. They started CPR and tried to revive her. The paramedics arrived, but were unsuccessful in helping her. Candida Heaton, also a friend of the victims, Andrea Farrington, described how she was working at Mellow Mushroom. She's a nurse, a nursing assistant, so she ran over to see what she could do to help. She took Andrea's hand, and you can actually hear her in Mike Barney's audio over video body camera with her saying, "Come on, Andrea," trying to encourage Andrea, trying to really get her to survive. You heard how she gave CPR and how she didn't even realize that this was her friend, Andrea. She was just working so hard and trying to revive Andrea Farrington. Andrea was taken to university hospitals, and you heard from Dr. Olivia Bailey, who is a staff doctor in the emergency room and professor also in the Carver College of Medicine. She described the team that worked on Andrea. She described the efforts they made to revive and save Andrea, but they never could get her heart beating again. She was pronounced dead at 8:05 p.m. that evening. You heard then from Cheryl Farrington. Cheryl was one of the ones who was called in a family, and you have to have somebody to identify who who this body is, who is this person who died. She told you how she and her daughter Cassie, Connor Sorovi, Andrea's boyfriend, David Farrington, Andrea's father, were there, and how she and Cassie, Connor, went back into the room where they saw her daughter, who was dead, and she can say that that was her daughter, Andrea Farrington. You heard from Dr. Marcus Noshelski. He's a forensic pathologist, and he performed the autopsy on Andrea Farrington. And he told you that she died from the 3 gunshot wounds that pierced her heart and spinal cord. He told you, as had Olivia Bailey, that there was nothing that anybody did in trying to revive her that caused her death. It was the gunshots that the defendant fired that actually caused Andrea Farrington's death. So the state has proven beyond a reasonable doubt, element number 2, that Andrea died as a result of being shot by the defendant. The next element that the state has to prove is the defendant acted with malice aforethought. Now, this is not a typical term that we use in everyday life, so the judge has just defined it for you. And malice, the judge tells you, is a state of mind which leads one to intentionally do a wrongful act to the injury of another or in disregard of the rights of another out of actual hatred or with an evil or unlawful purpose. It may be established by evidence of actual hatred or by proof of a deliberate or fixed intent to do injury. It may be found from the act and conduct of the defendant and the means used in doing the wrongful and injurious act. Malice requires only such deliberation that would make a person appreciate and understand the nature of the act and its consequences, as distinguished from an act done in the heat of passion. Malice aforethought is a fixed purpose or design to do some physical harm to another which exists before the act is committed. It does not have to exist for any particular length of time. Malice aforethought may be inferred from the defendant's use of a dangerous weapon. So as you hear, there are different ways for you to determine if the defendant acted with malice aforethought. You can look at all of the evidence in terms of what was going on. You also may infer it, if you choose to, because he used a dangerous weapon. And what is a dangerous weapon? A gun. As you were instructed by the judge, the gun is, by definition, by the law, a dangerous weapon. So the use of a gun actually equals malice aforethought. The defendant used the gun to kill Andrea Farrington, and he had malice aforethought. But in addition to this inference that you can make, the state also put on evidence, and we would ask you to look at it. You heard from Jessica German, and you'll have a chance to look at all the text messages. You'll see that some of the text messages are between Andrea and the defendant, and others. And State's Exhibit number 20 actually put together, and we have it in different colored versions, so you can see who was sending them or who it was to, whether it was from Jessica or Andrea or Kelly Kozak in the last few days before and up to and on June 12th. And you heard Jessica read the text to you. In the text of June 12th, the defendant refers to Andrea Farrington as a bitch. He texts Jessica, "I'm tired of her games. I'm tired of being her little puppet." He has that feeling of anger. He expresses that feeling of anger to Jessica German. In addition to that, though, there's the evidence of the statements he made to Special Agent Rick Ron. He describes her as backstabbing, blood-sucking whore. That's his description of Andrea Farrington. You heard additionally the statements that he described when he was being interviewed even more recently by Dr. Kokler. He said he felt like he was being manipulated again. When he heard Andrea was interested in someone else, he felt angry. He described the feeling as he went to the mall as cold fury. This is malice aforethought. He had a fixed evil intention, and additionally, he used a firearm, a gun. So whether you take it as the inferment from having what you can infer from the use of the gun or the statements he made, those are proof of malice aforethought. In addition, what he texted to Andrea, and again, you will see those in State's Exhibit 20A, 20B, and I believe the Defendant's Exhibit LL, and possibly the new, I think it's Defendant's Exhibit T, T2, what he said to Andrea. Things such as, so it's slutty to sleep with me, but not slutty to sleep with someone else, or words to that effect. And when she asked if he was mad at her, he responded with something, what kind of motherfucking question is that? It's misspelled in the text, so I misspelled it here. That shows you what his thinking was and what his attitude was towards Andrea even before he shot her. So the state contends we have proven beyond a reasonable doubt that the defendant acted with malice aforethought. His use of the gun, all the things he said to Special Agent Rick Ron, to the different psychiatrists, his text messages to different people, all show that he was thinking an ill, evil purpose, that he was acting with malice aforethought. Finally, the last element the state has to prove is the defendant acted willfully, deliberately, premeditatedly, and with a specific intent to kill Andrea Farrington. The judge defines these terms for you more. Specific intent means not only being aware of doing an act and doing it voluntarily, but in addition, doing it with a specific purpose in mind. Because determining the defendant's specific intent requires you to decide what he was thinking when an act was done, it is seldom capable of direct proof. Therefore, you should consider the facts and circumstances surrounding the act to determine the defendant's specific intent. You may, but are not required, to conclude a person intends the natural results of his or her acts. The judge goes on to define willful, deliberate, and with premeditation. And willful means intentional or by fixed design or purpose and not accidental. To deliberate is to weigh in one's mind, to consider, to contemplate, or to reflect. Premeditate is to think upon a matter before acting. The judge further goes on to tell you that deliberation and premeditation need not exist for any particular length of time before the act. So we don't have to show that he had 3 minutes, 10 minutes, an hour or more to contemplate. It's no definite length of time. The state will tell you and will contend that the fact that the defendant pulled the trigger once and shot her was one act. He then had time to premeditate, and he chose to pull the trigger a second time. And then again, he chose to pull the trigger a third time. That's premeditation. That's what he intended. You're further instructed, though, that the defendant in this case has raised a defense of what's called diminished responsibility. And the judge defined this for you as it means a mental condition which does not allow a person to form a premeditated, deliberate, specific intent to kill. Diminished responsibility does not entirely relieve a person of the responsibility for his or her actions, and is not the same as an insanity defense. You should determine from the evidence if the defendant was capable of premeditating, deliberating, and forming a specific intent to kill. And another instruction the judge read to you is you really have to take all of the evidence as a whole. Consider it all when you're making the decision on each of these elements. The judge also further goes on to tell you that there's evidence of willful, deliberate premeditation and specific intent with the use of a gun. An inference comes, and what it is if a person has the opportunity to deliberate and uses a dangerous weapon against another person, against another, resulting in death, you may, but are not required to infer that the weapon was used with malice, premeditation, and specific intent to kill. So that first shot alone is enough for you to find the defendant had specific intent, premeditation, and it was used with malice. You can consider that in addition to the second shot and the third shot. Now, I want to talk a little bit about some of the ways to consider the evidence. And the judge talked to you about circumstantial versus direct evidence. And the judge says, as I tell you, I'll tell you this case has both. And the law makes no distinction about whether something is circumstantial evidence or whether it is direct evidence. Direct evidence is actual knowledge from somebody who saw something, heard something, etc. Circumstantial is a proof or a set of events that you can put together and figure out the conclusion. And we talked about this during jury selection. You may not see everything, but you can certainly figure out what happened. So what is the direct evidence in this case? The direct evidence, in this case I should say it has both direct and circumstantial. This direct evidence was evidence from the witnesses who saw the defendant shoot Andrea Farrington 3 times. The defendant actually told Jessica German what he intended to do. The defendant told Trooper Engsler, Sergeant Varela, Special Agent Rick Ron, Dr. Logan, Dr. Anderson, and Dr. Kokler what he did. Now I want to talk first, though, about what's the direct evidence of the willful, deliberate, premeditated, and specific intent. And I'd ask you to take a look at the text to Jessica German that he sent at 4:36, almost 3 hours before he shot Andrea Farrington. What he texted her almost 3 hours before was, "I'm about to drive home, get my Glock, and shoot this bitch. I'm tired of her games. I'm tired of being her little puppet." 3 hours before, he already was telling somebody what he was going to do. In addition, we have the direct evidence of the fact that he used the gun. As I mentioned, he used it not only once, not twice, but 3 times and shot Andrea Farrington. You can make that inference about what he intended because of that. In addition, though, what was the amount of time he had to premeditate and plan what he was doing? Deanna Brown described for you how she saw the defendant and he was very angry and upset. She tried to calm him down. Now, he did not tell her, who he knew was a friend of Andrea Farrington, what he was thinking about doing to Andrea Farrington at that time, and just complained about his boss, Saya Sisime. You heard how Scott Penrod could not find the defendant at 6:40 p.m. And so we know the defendant probably left the mall between then and around 7 or so, when it was discovered that he had left his keys and his radio in the security office at the mall. But look also at what the defendant's actions were. The defendant did. He turned in his radio and keys, left the mall. Sometime probably between 5:50 and 6:40, from the last time he was seen at 5:50 by Deanna Brown to 6:40 when he couldn't be raised on the radio. He drove home to North Liberty, And you heard from Detective Rich Smith, as well as the investigator for the defense, that it may take anywhere from 10, I believe, to 15 minutes to drive home, depending on what the traffic is. The defendant had that much time to think about what he was going to do, and this is sometime after he had already texted Jessica German. When he got home, what did he do? Grabbed his loaded gun, he loaded extra magazines, he got his boots with a knife. He got his backpack and he filled it with clothes. He loaded the backpack and his extra ammunition into his car. He loaded his knife and hatchet collection that his mother told you was something that was special to him, that he had had from his grandfather, and he put that in his car. He drove the 13, 14, 15 minutes back to the Coral Ridge Mall. When he got to the Coral Ridge Mall, what did he do? He parked at the closest parking spot to the Iowa Children's Museum Welcome Center. He parked, it was a handicapped spot. You heard from Bryn Stanton Anderson as well as Catherine Ogden, and the defendant acknowledged that in talking to Special Agent Rick Ron. Bryn Stanton Anderson told you how he got in the back seat and kind of flipped on his fedora when he got out of the car. At some point he had put the gun in his pocket. He entered the mall at the doors closest to the Welcome Center. He acknowledged Catherine Ogden with kind of a smile, or she described it kind of a smile, kind of a nod to her. And keep in mind, he did not shoot or even argue or do anything to Catherine Ogden. He pulled the gun out of his pocket when he got close to Andrea Farrington. He did not stop to talk to her. He did not wait for her to turn around. He shot Andrea Farrington. He shot her 3 times. He shot her in the back. He shot her from 3 to 5 feet away from her. He knew, and he told the psychologist and Rick Ron, he knew he had a gun. He knew it was lethal. He understood what he was doing. He said to one of them he shot for her torso, and when it was brought up later, did you know she was dead? It was like he said something to the effect of he knew kind of the human body or something to that effect, the biology, and that shooting her in the torso would likely lead to her dying. He did not stop to help Andrea. He walked and then ran down the main corridor of the mall. He made eye contact with Ryan Ross, his friend. He made eye contact and heard Rudy Rodriguez speak to him. He then ran down the side corridor and out of the mall, and he thought at that point in time that he should dispose of the weapon, so he threw it into the large compactor. He then ran north through the parking lot, and then east, and then back south to his car that was parked in the parking lot. He then hurriedly drove through the parking lot, and you saw the security video with him leaving and how quickly, and he's trying to get around other cars. He told Special Agent Ron he took 2 rights out of the mall, and the second right got him onto Interstate 80 going east. Where he drove east, he disposed of his cell phone because he thought they might be tracking him. So he threw it out alongside Interstate 80 and told Special Agent Ron approximately where it was. He disposed of the extra ammunition somewhere in the ditch along Interstate 80. He got, and I want to talk a little bit, but go back for a second. He talked about the cell phone. And you will see a cell phone that was found along Interstate 80. It was broken from being thrown out of the window, but they were able to retrieve it and use it to gather evidence. So he said he disposed of the extra ammunition. He got money at the Walcott pilot station. And State's Exhibit number 27 shows the receipts that were in his wallet, including the transaction at the pilot station that day that showed he withdrew $200. I believe at some point he also said, couldn't get more, should have maybe thought about that sooner when he was talking to Special Agent Rick Ron. This information was consistent with what he told Special Agent Rick Ron, and when they found it, they could find the receipts and verify that. Once he was stopped by Trooper Engsler and Sergeant Varela, when they asked him about what had happened or if he knew why he was stopped, he said, "I shot someone at the mall. I shot Andrea Jean Farrington." And we have a clip from that interview.
What did you say your first name was?
Alexander.
Alexander Kovak?
Kozak.
What?
Kozak.
Kozak. Kozak. All right, so you know why you got stopped? Okay, tell me why you got stopped.
Because I shot someone at the mall.
So you got stopped because you shot somebody at the mall? Okay. Who did you shoot?
Andrea Jean Farrington.
He knew what he did. This wasn't a mistake. This wasn't because of some mental defect or mental illness. He did it because he wanted to. He did it because he was jealous and he was mad. He wanted Andrea to pay the price for bruising his pride. So let's talk about, though, what was the defendant's state of mind. And you heard from 3 experts in the field of psychiatry or psychology at the end of last week. So you need to ask yourself, looking at all of the evidence, did the defendant act willfully, deliberately, with premeditation, with a specific intent to kill Andrea Farrington, or did he have a mental defect that prevented him from acting willfully, deliberately, and with premeditation? What was the defendant's state of mind? So let's look at what he said, what he told people. As the judge told you, understanding what somebody is thinking is rarely capable of direct proof, and so you really need to look at the surrounding circumstances and what else he does to decide what he was thinking at the time. All 3 of the experts in psychology and psychiatry said the defendant was coherent, he was intelligent, or at least average intelligence, he had no substance abuse problem, he had no mental health history of any kind. He had nothing when they met with him that would indicate that he had had a prolonged or ongoing mental defect or mental problem that prohibited him from doing regular things, including planning. But what did the defendant say? Excuse me. And what do we want to talk about? Actually, I want to talk a little bit about the text messages here. Because the text messages give you some indication about what the defendant was thinking and the reasoning. It doesn't tell you really why, other than to understand his jealousy and bruised ego. The text messages, and you heard the relationship started, I think they met in December, but the relationship started in around February of 2014. They texted a lot. I think the estimates were 8,000, I think Mr. Parrish said in his opening statement. I think the defendant told one of the psychiatrists it was 60,000, probably somewhere close to 8,000 to 10,000. They texted a lot. There's no dispute. There's no dispute that they had some kind of relationship back February, March. There was lots of text messages between them. You also heard from Detective Rich Smith that the text messages abruptly stopped. I believe it was April 29th. And they didn't resume until June 5th, I believe it was. Or excuse me, June 5th, and I apologize for my typo in here. And then the text resumed around the early part of June 5th or so, and continued up into June 12th. You can use those to decide kind of the defendant's state of mind. He told Dr. Kokler and the other psychiatrists it was kind of a hot and cold, off and on again relationship. It was something that they had apparently broken up before without serious consequence to Andrea Farrington, but had decided to resume it. And you heard the text messages that were read to you, and you'll get a chance to look at them, that when they started up again on June 5th, they were clearly starting up again in a relationship that was close. But on June 11th is when Andrea said she was backing off, and you can read those text messages and figure it out. He told Detective Rick Ron, that the messages, that when they had broken up, he'd continued to text her the next day to try to get more information. Why? Excuse me. But what was it that actually kind of set him off the most is when she wrote, "Fine, bye." And this was after she had said she was interested in somebody else. He had questioned her about it, and she had asked, "Are we still friends?" He had sent back the, "Do you, M and F, what do you think?" kind of thing. And when she responded, "Fine, bye," that's when he got angry and admitted to Detective Rick Ron that that's when he drove to get his gun. He said, "Part of me thought I was just going to up and leave, and then the other part of me didn't want to leave but wanted to kill her." That's what he told Rick Ron his thinking was. "It had to happen," he told Rick Ron. When asked what had to happen, he said, "I had to shoot her." And Special Agent Rick Ron told you that when he was questioning the defendant, and the thing that seemed to give him the most pause is when he asked, if Andrea Farrington was here today and you could say something to her now, what would you say to her? And he said, "Andrea had the right to be afraid of me." That all goes to show what his state of mind was. You also heard when Special Agent Ron asked the defendant what crime he had committed, the defendant said, "I don't know the proper degree, but that's murder, premeditative murder." When asked to clarify, the defendant said, "Yes, sir, that, because I thought of it and I carried it out." And we have that clip for you.
You understand right from wrong.
Yes, sir, I do.
You know what you've done. You know that you've committed a crime.
Yes, sir.
What crime have you committed?
I don't know the proper degree, but that's murder, premeditated murder.
You've committed premeditated murder, is that what you said?
Yes, sir, that is, I thought of it and then I carried it out.
You had mentioned to me, Alexander, that you went in there with basically premeditation, and it's the word you used.
Yes, sir.
And what does that mean to you?
It means there was some serious thought to it and it was deliberate.
It was deliberate? And when you say it was deliberate, meaning shooting Andrea?
Yes, sir.
Okay. With the intent to kill her?
Yes, sir.
Okay. Because you're angry over some text messages and essentially kind of breaking up with her, is that accurate?
Yes, sir.
Or her breaking up with you?
Yes, sir.
Those are the defendant's words. You can use those to decide what his state of mind was and what his intent was on June 12th of 2015. Special Agent Ron went on to make sure that the defendant was fully aware of the thoughts, surroundings. He had been read Miranda rights, and you heard repeatedly Detective Ron, or Special Agent Ron asking him if he understood his rights. The defendant said he was fully aware. And when it was pointed out, he did not seem terribly upset, and asked why. The defendant said, "That's a good question. I really don't know. But again, I'm not one for breaking down crying. I've done that maybe 3 times in my life, and the rest of it just rolls off of me." When asked how he felt when he reached inside his pocket to pull out the gun, the defendant said, I was actually terrified about what I was doing. I knew it was wrong and that I shouldn't be there in the first place. But then the feeling that I felt off and on for the past 3 or 4 months hit me, and I didn't care anymore. Defendant's state of mind also shows that when he left the mall to go home, he was thinking she was a backstabbing, blood-sucking whore, is what he told Special Agent Ron. He said, one side of me didn't care about her breaking up with him, and the other side of me wanted her to die. He denied that he had ever hurt his wife or would ever hurt his wife. Going again to his state of mind, and you heard in the clip, he said premeditation means there was some serious thought to it and it was deliberate. When we went through and you heard this, when he went through and when you say it was deliberate, meaning shooting her, he said, yes, sir, with the intent to kill her, yes, because you were angry about her breaking up with you, yes, sir. That shows what his state of mind was. Now, I want to talk a little bit about Dr. Logan. Dr. Logan even has to tell you that the defendant admitted shooting Andrea Farrington. He acknowledged that there was no prior psychiatric history reported by either the defendant or his family or in any of the reports, no psychiatric history. They reported even no prior violence to anyone. He didn't report any prior psychotic behavior, hallucinations, delusions, but he diagnosed him with borderline personality disorder and intermittent explosive disorder. And if you recall the testimony of Dr. Logan as well as Cindy McComas and his sister, Miss Wynn, and even his wife, none of them described any kind of violent behavior towards another person. The most they could describe was an occasion when he was in 9th or 10th grade when he got mad over some discipline at school, and he was very angry about it, didn't think it was fair. Another time he had become angry when somebody had made an inappropriate comment to his younger sister. He'd also gotten mad and threw down a mouse and shoved the keyboard a little when he was mad about a YouTube video not coming up after they had had work done in their computer. A time when he threw down a screwdriver when a bolt wouldn't come out of a license plate. That was the extent of the kind of temper that was described by Miss McComas and Miss Wynn. Then when Kelly Kozak came on, she told you he's been getting angry a lot. He's been getting very angry. He accuses me all the time of going out with other men. He doesn't let me go out with other people. But even Miss Kozak didn't say there was any violence there. And you also heard what she had said initially when she was first interviewed on June 12th, when she denied he lost his temper very much. You heard how the defendant was also interviewed by Dr. Anderson, who is while not a forensic psychiatrist, has been a psychiatrist for many, many years and certainly seen more than just eating disorder patients in his long career. He also reported that the family reported no psychiatric behavior or psychiatric history, and the defendant confirmed this. They reported no prior violence to any person, never reported any psychotic behavior, and he found that the defendant suffered from no mental illness at all. He had traits of an antisocial personality disorder, but not even enough, Dr. Anderson thought, to diagnose him. Then you heard also from Dr. Kochler. And to Dr. Kochler, the defendant admitted that he shot Andrea Farrington. When asked what he intended to do when he entered the mall, he said he intended to shoot her. He knew he had a gun. He knew the lethality of the gun. He knew he shot her 3 times. He knew he shot her in the torso. Dr. Kochler diagnosed the defendant with another specified personality disorder with mixed personality features. And Dr. Logan had diagnosed the defendant with borderline personality disorder. And Dr. Kochler explained what a personality disorder is. It's kind of a description of the traits that a person has. It's something that stays with them. It describes kind of what their thinking is. However, a personality does not prevent or direct the defendant's actions, and he can plan and carry out his goals. Planning is something that even Dr. Logan had to acknowledge the defendant was able to do. He could plan. And you can use that in deciding whether the defendant had any mental defect that prohibited him or prevented him from forming the specific intent or willfully, deliberately, or premeditatedly killing Andrea Farrington. As I mentioned, none of the psychological experts found he suffered from hallucinations and delusions. It wasn't like he was unaware that she was Andrea Farrington, unaware that what he was holding was a gun. He didn't have hallucinations of somebody else being there or somebody else telling him what to do. All three agreed, though, that he lacked empathy. That's not a defense to murder. All three experts agreed that the defendant could plan, so you could find he could deliberate and premeditate and have specific intent. And two of the three experts determined that the defendant did not suffer from a mental condition on June 12th other than one diagnosis of an otherwise unspecified personality disorder or just personality traits. You heard also from Dr. Anderson and from Dr. Kokler that the defendant's expert witness, Dr. Logan, who came up with this diagnosis of intermediate explosive disorder, was something that didn't fit the criteria. He did not have the history of doing these things. As Dr. Kokler said, if somebody with this in and out of jail, have lots of problems, lots of violence, you've seen no violence from the defendant until he shot and killed Andrea Farrington. There's nothing to substantiate that diagnosis. And keep in mind, the judge told you in deciding on who to believe with the expert testimony, you can decide to believe some, all, or none of their testimony just like you can any other witness. You can decide which experts you believe are the most credible. You can decide which expert's testimony is consistent with other evidence you believe. So take their evidence, but don't exclude the rest of the evidence. Look at all of the evidence when you're deciding what was in the defendant's mind on June 12th as he shot Andrea Farrington and what his mind was leading up to that. The state believes that we have proven beyond a reasonable doubt the charge of murder in the first degree, but I want to quickly go over what the other, what we call lesser included offenses are, and that the judge by law needs to instruct you on these as well. Murder in the second degree is the next one. So if you find that the state has not proven the premeditation, specific intent, deliberate, willful, etc., then you would look at murder in the second degree. And it has basically the first three elements of murder in the first degree minus the specific intent, willful, deliberate premeditation. Something else, though, is that murder in the second degree does not require the specific intent to kill. Diminished responsibility, the defense that the defendant has raised in this case, does not apply to second-degree murder or any of the other lesser included offenses. So even if you find that the defendant had diminished responsibility, you would still find the defendant, if you believe that he shot Andrea Farrington, that she died as a result of being shot, and he had malice aforethought, he would be guilty of second-degree murder. So even if you believe he had a diminished responsibility, it only goes to the highest level of charge, none of the others. Malice aforethought, once again, you can infer that because of the use of his gun in second-degree murder. You can also, look at all of the evidence, and I'm not going to go through it again here, that showed what his malice was and malice aforethought at the time that he shot Andrea Farrington. Next, the judge instructs you on voluntary manslaughter, and this is kind of the classic kind of charge where somebody walks in and they see their spouse in bed with another person and they immediately react. And so the elements of this one are about June 12th, the 12th day of June 2015, the defendant intentionally shot Andrea Farrington. Andrea Farrington died as a result of being shot, and the shooting was done solely by reason of sudden, violent, and irresistible passion resulting from serious provocation. And the judge defined that for you as a serious provocation is conduct that would cause a reasonable person to have a sudden, violent, and irresistible passion. passion is not sudden, violent, and irresistible, if there is an interval of time between which a reasonable person would, under the circumstances, have time to reflect and bring his passion under control and suppress the impulse to kill. Words alone, however abusive, insulting, cannot be serious provocation. So really, this does not fit at all for this offense. There were only words that she spoke. There was no real serious provocation on the part of Andrea Farrington, and certainly had time to think about what he was doing. Voluntary manslaughter, the state would contend, again, doesn't really fit in this one, but you must be instructed on it. And it's basically that on or about June 12th of 2015, the defendant recklessly fired a gun toward Andrea Farrington in a crowded mall. When the defendant committed the crime, he unintentionally caused the death of Andrea Farrington. The state does not believe that there is really evidence to support this particular one, and we believe that the evidence better fits with murder in the first degree. Now, I'm going to quickly go on some of the other instructions the judge gave you, and this is just how you can consider the evidence. So there are many factors which you can consider in deciding what testimony you believe, whether the testimony is reasonable and consistent with other evidence you believe. So when you're considering the doctor's testimony, consider what other evidence you believe and see what seems more plausible to you, or do they fit together. You can ask whether witnesses have committed inconsistent statements. Oops. Sorry, I'm off on my pages here. But circumstantial evidence or a combination of both, and in considering the evidence, make the deductions and reach the conclusions which reason and common sense lead you to make. So this is something we talked about a little bit in jury selection, and really we want you to use your common sense. This is not in a case where you set your common sense aside. Use your common sense when you're looking at the evidence in this case. Go in evaluating the evidence, using your observations, common sense, and experience. Try to reconcile conflicts if you see them, but if not, consider the evidence that you find more believable. And the testimony, here we go. Factors to consider: whether the evidence is reasonable and consistent with other evidence you believe, whether a statement's made inconsistent statements, a witness's appearance, conduct, age, intelligence, memory, and knowledge of the facts, the witness's interest in the trial, their motive, candor, bias, and prejudice. Finally, I want to get to what we've been talking about since the beginning of jury selection as well. For you to find the defendant guilty, you have to find that the state has proven each of the elements beyond a reasonable doubt. And the judge described that for you. It's if, after a full and fair consideration of all of the evidence, you are convinced of the defendant's guilt, then you have no reasonable doubt, and you should find the defendant guilty. But if, after a full and fair consideration of all of the evidence in this case, or from the lack or failure of evidence produced by the state, you are not firmly convinced of the defendant's guilt, then you have a reasonable doubt, and you should find the defendant not guilty. So what is a reasonable doubt? A reasonable doubt is one that fairly and naturally arises from the evidence or lack of evidence produced by the state. It's not speculation. It's not just kind of a consideration. It's what remains after you deliberate. And what you should do is judge it in the context of reality and distinguish this from natural doubt. There's always a threshold doubt. There's an inclination to believe what we want to think is the easiest or the most accepting version, the thing that we can live with the easiest. In jury selection, I asked you, how many of you, when you hear that somebody shot another person, say, he must have been crazy or she must have been crazy? There is that part of us that we want to have that natural doubt. We don't want to believe that somebody sitting here is responsible for doing this. We don't want to believe that somebody who's walked among us, who was a security guard, who was married, who had friends, who had a mother and sister, could do this to another person. That's the natural doubt in us. We don't want to believe that. But as jurors, you're required to look at this. You have to decide, was there sufficient evidence that after deliberating, you were fully and fairly convinced of the defendant's guilt? Then you have no reasonable doubt. A reasonable doubt is not 100% proof. That would never be the case. It's not absolute proof. We don't have a utopian standard. We don't have an ability to go into somebody's mind and say exactly what they were thinking. We didn't have video surveillance everywhere for you to see exactly. But beyond a reasonable doubt is not meant to be an impossible burden. On June 12th of 2015, as Andrea got up and got dressed that day, she put on her jeans, her tennis shoes that you saw in some of the photos from the crime scene. And she put on her Children's Museum t-shirt with playologist written on the back because that was her job. When she got ready that day and was maybe contemplating her day, hoping to be able to keep that job, come back to it possibly, she didn't think when she put on that job that by the end of the day, there would be 3 bullet holes in that shirt. That she would never make it to her 21st birthday 11 days later. That she would never get to spend time with her friends and her sister and her family again. And why? Why did she not get those opportunities? Because the defendant intentionally, deliberately, with premeditation, and with the specific intent to kill Andrea Farrington, and with malice aforethought, went into the Coral Ridge Mall, pulled his gun from his pocket, and shot her at point-blank range 3 times in the back. That's why we're here. That's what he did. He did it out of jealousy and because his pride was hurt. I want you to know that we trust juries. We trust juries to listen to the evidence, and you have done a wonderful job. You have been paying attention, many of you taking notes at times. We trust you with the ability to apply the law that the judge has just given you. We trust you to make a fair and right decision. We trust you to do the right thing, and we thank you. This is not an easy job. This has been an emotional case. This is an important case. It's one where somebody lost their life. And now we ask that you hold him accountable and find the defendant guilty of murder in the first degree. Thank you.
Ladies and gentlemen of the jury, there's only a couple of natural breaking places in what is left to be done here today. And with the belief that if I break later, you'll have a very, very late lunch, I'm going to break at this point for an early lunch. I would say let's just take an hour for lunch. I'd like to have you back at 12:20. If you could please be back at 12:20. If you need a couple minutes extra and you're not here, you know we won't start without you. But try to be back by 12:20. It's very important during this break that you remember your admonition. You have not yet heard the closings from both sides in this case. We'll be in recess until 11 or 12:20. Thank you.
Other than that, I have no additional record. I would also make that this motion under both the Iowa Constitution, the United States Constitution, and so it applies in both.
Your Honor, I certainly did not intend to make any reference to the defendant not testifying. I think I was pointing out to him as the witnesses had. I don't remember exactly what was happening in 11 whatever, but I think I was trying to go through and have explain what the witnesses pointed to or who we were referring to. There was certainly no comment on whether the defendant testified or not. I said nothing about the defendant testifying in the case. I think there was nothing in my closing argument would suggest anything about the defendant testifying. I referenced his statements he made to the investigators in the case as well as the psychologist, but certainly nothing else about whether he should or anything else about him testifying or not. And I would ask the court to overrule the motion for mistrial.
The court overrules the motion for mistrial at this time. I'll see you all back at 1:12.
Thank you.
You sure? Okay, we're gonna be ready to make the, our response right after this, okay? So just relax, go with the deputies and come back. Hey Brenda, we wanna go ahead and set this up now?